Good morning, everyone. My name is Linda van Beek. I'm the Executive Director of Global Compact Network Netherlands. On behalf of Global Compact Network Netherlands, I would like to welcome you to this webinar with the title, The Impact of Climate-Related Court Rulings in Light of the IPCC Report and UN Guiding Principles. Why are we organizing this webinar? Well, first of all, because both recent climate-related court rulings and the IPCC report have attracted our attention. The recent Shell case puts the meaning of the Paris Climate Agreement for companies in a new light. How companies can be held responsible and liable for their impact on climate. It was the first time that in a court ruling, a private company was obliged to reduce its overall CO2 emissions by a fixed percentage and also within a fixed time frame. Although the Paris Agreement plays already a big role in the climate ambitions of companies, it might have felt as a surprise that the way how companies have incorporated these targets in their climate actions can be subject to court rulings. The IPCC report was probably less surprising because we are, of course, aware of the seriousness of global warming and climate change. But the report can be a trigger to have a closer look at the role of companies and to define their responsibility and liability. Secondly, as a sustainability network, we tend to stimulate more companies to accelerate their climate ambitions as part of their commitment to the 10 principles and the SDGs. In this way, we would like to provide a deeper analysis of these important developments and what they will mean for business. For example, could the legal base, which was used in the Shell case, the unwritten standard of due care, be used more often to make the UN Guiding Principles legally enforceable? And should we consider the UN Guiding Principles as soft law or hard law? And what does this court ruling mean for policy developments as the intention of the European Commission to come up with a European due diligence legislation? And how do you know if your company's sustainability actions are good enough, actually? And what does this court ruling and the IPCC report say about the division between responsibilities of companies, civil society, and governments? We hope to give you answers on these kind of questions in this webinar. I'm happy to announce you our expert of today, Martijn Scheltema. Martijn Scheltema is partner at Pels Rijken and member of the Dutch Supreme Court Bar. Martijn is specialized in human rights and climate change issues, and he has advised the Dutch government on legislative options in the business human rights area. We are really looking forward to learn more about this important topic. Martijn, the floor is yours.
Yeah, thank you, Linda, and it's a real pleasure to be able to present here in the webinar of the United Nations Guiding Global Compact Netherlands. And I think, as you already kind of explained, this is a rather, well, I think provoking or thought-provoking maybe decision from the Dutch courts, which goes beyond, I think, what we have seen so far. So that's indeed a interesting development, also from a legal perspective. And so I will try to first explain a little bit more about the court ruling. So 15-20 minutes for that, and then we'll open the floor for questions and of course all kind of other observations and things you want to discuss. And you can put your questions already if you have them in the chat. And of course, when we have started or opened the discussion, you can also flag with a raised hand that you want to say something and discuss things, which is also possible, of course. So yeah, thank you. Next slide. Well, Linda already alluded to this. Well, the UN Emission Gap Report shows that, well, a lot more has to be done to meet our kind of expectations in terms of the temperature range and try to keep it below 1.5 or 2 degrees. As you see in this picture, well, if we look at the current policy scenarios, or even unconditional or conditional scenarios with the national determined contributions to greenhouse gas reduction, well, we are far from what we really need in terms of the 2.2 2 degrees or 1.5 degree. So it really shows that well, there is a dramatic strengthening of ambition needed to reach the 2 degrees or 1.5 degrees range. And next slide, please. So it's not kind of surprising that these kind of issues now also have reached the courts. And of course, it's not the only case. We have like 1,800 climate-related cases pending, mainly US, but also in other countries. But so far, we of course do not have a kind of global order to reduce greenhouse gas emissions, including in value change, because well, we have some national legislation on that, but in terms of global agreement on what business should do in terms of reduction is not yet there. So yeah, that's still kind of quite nationally oriented. But this Shell ruling of the Dutch courts kind of really changes that. Though, of course, the court also observes that climate change is not exclusively Shell's problem, of course, but a shared responsibility to act. And also, if governments do not implement or implement insufficient measures to reduce greenhouse gas emissions. So the responsibility of Shell, according to the court, goes beyond what governments do. So it's not enough to say, well, I'm kind of meeting all the national requirements which are set in many countries, but they really have their own responsibility to reduce greenhouse gas emissions, kind of independent from what states do or are willing to do. Next slide, please. And before we dive somewhat deeper into the Shell ruling, of course, it is a quite lengthy ruling. It has many very interesting and also sometimes nitty-gritty legal details. And of course, in this 15-20 minutes, it's not possible to discuss all and not even touch upon most of them. So I will pick some of the important issues I think the court has addressed and which are important, I think, for our meeting today. But of course, that's much more to it than I will discuss today. But what the court first does, and I think that's quite sound in terms of the existing scientific research, is an analysis of climate change issues and the consequences it has, also based on scientific data, like the UNEP emission gap report, which kind of shows that if we keep on the current pace in terms of reductions, we'll have a 3.2 degrees raise in 2100. And I think in terms of what the court has assessed, that's not kind of really contested in the case, so that both parties were kind of in agreement on the analysis in terms of the climate change issue. The second thing the court observes is that Shell has a relatively large contribution to global emissions, 1.7% of global emissions, compared to, for example, the Netherlands with 0.4%, or the EU as a whole with 8.7% of global emissions. So in terms of the whole contribution of Shell, and that's of course not only Shell's own emissions, but also emissions caused by, for example, their buyers, the people who are kind of buying fuels from Shell. But that's a relatively large contribution. What is also good to note is that the claim was directed at the parent company, so the Royal Dutch Shell, and the parent company controls over 1,100 subsidiaries and other companies in the Netherlands, but of course also in many other countries. What's also interesting to note is that Shell actually has gathered knowledge on climate change risk already in the 80s and 90s in internal and external reports in terms of issues climate change may bring about. And the last thing, which is also interesting, is that unlike many other decisions, for example, the also recent decision from the Appellate Court in The Hague on the Shell Nigeria case in terms of oil pollution in Nigeria, where there was a kind of large piece dedicated to the governance structure of Shell and to which extent the parent company had options to steer the subsidiary in Nigeria. The court does not elaborate on governance structure in this case, and that is because it applies the UNGPs. And I will dive into that later, but that's an important thing, and I think also an interesting thing in this case. To explain a little bit further on which emissions the court ruling has an impact, it's good to note that the claim and also the decision from the court address scope 1, 2, and 3 emissions, and that's based on the World Resources Institute Greenhouse Gas Protocol, which kind of discerns these types of emissions. And scope 1 emissions are emissions from the Shell's the mother parent company itself or control facilities, for example, like subsidiaries. Scope 2 emissions are emissions from third parties who provide energy to Shell. And scope 3, and that's the most important part, are other emissions caused by operations of Shell, and then by parties who are not under control of Shell, such as end users, for example. And it's good to note that 85% of the emissions of Shell is scope 3. So the scope 3 emissions, well, reducing them has the kind of most significant impact. But the ruling then kind of addresses all 3 scopes, so 1, 2, and 3 emissions. Though, and then it's good to a little bit better understand how the court then decides that Shell has a obligation to reduce. It's good to see how the kind of which way the district court justifies that approach. And what it does is the whole decision is based on the Article 162, Book 6 of the Dutch Civil Code, which is a kind of very broad provision on unlawful acts, which kind of include all types of unlawful acts, and also opens the option to kind of bring in or fill in the norm with all kind of hard and soft law instruments, codes of conduct, and other types of instruments which may have some legal significance. So what the court does here is kind of fills in this open norm with 14 observations. For example, the policy setting position of Shell in the group, the scale of its emissions, the consequences of the emissions for the Netherlands, because the case was kind of filed as a kind of class action for Dutch society at large, and a little bit smaller part of impact which may arise in the northern part of the Netherlands. But the consequences thus for the emissions in the Netherlands. Also an important point of view, leverage over suppliers and end users, the court observes, as well as the onus and proportionality of a reduction measure for Shell, and the United Nations Guiding Principles and OECD guidelines as a mean to fill in this open norm. And next slide, please. Well, maybe most of you are kind of familiar with the human rights due diligence, but just to be sure, I have depicted it in this slide. It consists of 6 steps. First, you have to kind of embed responsible business conduct in the management systems and policies. Then, step 2, you have to identify and assess adverse impacts. 3 is to seize, prevent, or mitigate adverse impacts. 4 is to track implementation and results. 5, how to communicate on the impacts and how they are addressed. And finally, if adverse impacts are observed, you also have to provide or cooperate in remediation when appropriate, and that's when you have caused or contributed to the impact. Next slide, please. And so how the court uses the UNGPs is not in a direct manner. It does not say UNGPs are hard law, so Shell has to observe this hard law instrument. What it does, as said, the decision was based on the very broad unlawful act provision in the Dutch Civil Code. But then the court observes that this kind of broad provision also includes that also in horizontal relationships, so between private actors, the human rights of the European Convention, especially Article 2 and 8, have to be observed and also have relevance in this horizontal relationship. And what it then does is says, well, but then of course, if we look at the relevance of human rights in a relationship between a private actors and especially regarding business, well, then there is some international consensus on what business should do. And that international consensus is reflected by the UNGPs and OECD guidelines. And the Supreme Court already decided in the agenda case that this kind of common ground, so where international consensus exists over what is required in connection with certain human rights, that can be used to fill in these human rights. So it's a kind of three-step approach. First, the kind of overarching unlawful act norm, then observe that also business in horizontal relationships should respect human rights. And then, how that should be done is then filled in by the UNGPs and OECD guidelines. And it may be good to observe here that Shell already complied with steps 1, 2, and 5. So Shell has a policy on greenhouse gas emissions. It has also assessed risks in connection with this and also reports on it. And the interesting thing here is that the court also, pays attention, but also feels that's important what Shell says in its own reports. But it's good to of course, note that the UNGPs as such were not designed as a legal norm, because in the early early parts of this century, there were some within the UN some negotiations going on to define kind of human rights obligations for business that failed. And then Kofi Annan reached out to Mr. Ruggie, asking him to come up with a framework for this. And what Ruggie did is not kind of trying to develop a legal norm, but what he kind of in fact did was saying, well, how should business kind of deal with these kind of issues? How should they respect in practice what happens? So it's kind of more a managerial thing in terms of what should you do to respect human rights, and human rights due diligence is one of the core concepts of the UNGPs. But as such, not a legal norm, especially, for example, if we talk about exercise of leverage, well, that kind of, can hardly be seen as a real kind of legal norm, at least not as designed as a legal norm. So the UNGPs were not originally designed as a legal framework, but now are kind of increasingly becoming a legal issue. And as said, the court ruling relates to all scopes, so 1, 2, and 3 emissions. But then the interesting thing is that the court says, or kind of in the court order, kind of imposes a obligation of result in connection with scope 1 and 2 emissions. So there, Shell has the obligation to reduce these emissions by 45%. And that's a kind of obligation of result. So that result has to be brought about in 2030. But regarding scope 3, the court does not go that far. It just says and orders that Shell has to reduce, or at least has an obligation, a best effort obligation to reduce the greenhouse gas emissions in scope 3 by 45%, but that's a obligation of means. And so what happens there is that it may be possible that in 2030, although Shell did its best, the 45% is not reached regarding scope 3 emissions. Next slide, please. And then I think what kind of happens and what makes it quite interesting to use the UNGPs to fill in this kind of open unlawful act norm and human rights obligations of business, is that it kind of solves several issues. Because what the court did is saying, well, the parent company has developed a policy, but we feel that that policy is not sufficient and not effective, because it's kind of a well, nice thing in terms of, well, nice to have thing, but not so much a real obligation to reduce, because Shell already said in its own reports that it would reduce by 45% in 2035. So Shell already had a kind of, well, some achievements or objectives in terms of what they felt they should do. But then the court observes that that's not enough, because it should be not 2035 but 2030, and not effective in terms of no kind of binding commitments to do that. So it feels that the policy needs improvement, but then the unlawful act is the development of an insufficient policy in the Netherlands. So that's the starting point for the decision of the court. And then it says, well, of course, it's the Shell policy of the parent company, but of course, it's not only development of the policy, but you also have to implement the policy in your operations. And that's, of course, not only relevant in the Netherlands, but also abroad. And there, the court solves three issues. It's not clear on all these issues, but for some, it's really also, dedicate some reasoning to that. The first thing is the jurisdiction, of course, because it's the parent company in the Netherlands, then the Dutch courts have jurisdiction over the case, and well, I think that's kind of acknowledged and not a kind of really new thing, but it is interesting that, of course, in terms of implementation of the policy, that also relates to all the subsidiaries, but also end users, for example, in many other countries. So what happens is that, of course, talking about the parent company, well, it's kind of obvious that the Dutch courts have jurisdiction, but what it in fact does is, because it has to be implemented in many other countries, also de facto kind of creates a kind of global jurisdiction, because it's kind of now connecting to all operations of Shell around the globe. And also solves, of course, the issue of applicable law, where, well, of course, the court observes that the policy as such is the unlawful act. So that's why the Dutch law applies. One could also say, well, maybe not very kind of new, because if we talk about environmental damage, well, then the country where the environmental damage occurs, that law can also be applicable according to international private law. So, yeah, from that perspective, that's not a kind of strange thing in terms of applicability of Dutch law. But of course, also here, interesting thing is that the Dutch law applies to the Shell policy and also to the implementation of it. So Shell has to do things also vis-a-vis subsidiaries, for example. And that apparently also all depends on Dutch law. And so the applicable law, it seems kind of quite obvious, because it's the Dutch policy, and according to Dutch law, that policy is unlawful, at least according to the court. But then, of course, it has consequences also for many other countries. And again, then Dutch law apparently also applies to what should be done in those countries. Though the court is not very clear about that. And the last thing, and that's where the court not really dedicates any reasoning to, is corporate separateness. Because, well, so far, the kind of starting point is that Shell parent company is a separate entity, for example, from its subsidiaries, who also have their own legal personality. And so, and it's also kind of observed that a parent company, of course, can try to influence and may influence subsidiaries, for example, and try to set a kind of global policy, but it cannot at least in most countries, not provide, for example, specific instructions for the subsidiaries, because it's felt that the subsidiaries also have their own responsibility in terms of the subsidiary, and so the parent companies cannot just provide very specific instructions to the board of the subsidiary. So there is it's kind of observed as really separate entities, and so when one entity acts unlawful, that does not kind of per se means that then a subsidiary, for example, also acts unlawful. Whereas what the court now does by saying, well, Shell has to also implement the policy, kind of then goes beyond this kind of corporate separateness, because, well, apparently the court expects Shell to also ask subsidiaries to reduce, and yeah, whether or not that then results in specific instructions, well, that's a interesting question. But the court does not really address that issue. But well, what we see is implementation of the UNGPs then solves, looking at this policy, solves these three issues in terms of jurisdiction, applicable law, and corporate separateness. Of course, beyond the corporate separateness, the court order also raises some other questions. Though, and maybe to start with, I feel that the legal reasoning of the court is sound in terms of the implementation of the UNGPs, because I think indeed Dutch law allows the filling in of this open and lawful norm with human rights perspectives, and then the common ground method, as accepted by the Supreme Court also in agenda, also allows to kind of fill in these kind of expectations in terms of human rights with the UNGP. So far, I think the reasoning of the court is sound. Shell, of course, appealed Shell appealed the decision. So we'll see what happens with the appellate court. But I think so far, yeah, the legal reasoning is sound. But the court order raises some questions, maybe others than I have mentioned here, but these are, I think, quite relevant ones. For example, how far does the order reach in terms of, are we also looking at emissions caused by processing of waste in value chains, for example, because those can also be connected to Shell operations, but yeah, does the court really feels that it should go that far? Another question is, well, why defend 45% reduction? Because that's based on 1.5 degrees limit, whereas of course the international consensus is still more on the 2 degrees limit. But maybe here the problem is that Shell already had a 45% in its own reports in terms of we want to be there in 2035. So maybe the court then thought, okay, well, then we'll take the percentage you already have in your own reports as well. And I think the most challenging one is whether the obligation of means or the best effort obligation regarding scope 3 is met, because there the court order does not include a kind of obligation of result, but only a best effort obligation, a significant best effort obligation, as the court calls it, but still it's a best effort obligation. So it is possible that although Shell does its best, the reduction is not met or not achieved in 2030. So one of these questions could be, well, how to deal with end users? For example, does Shell need to ask or even compel end users to compensate emissions? And if they do not want to reduce, should they stop selling fuels and, for example, only produce green hydrogen, or well, take some other measures? And there, I think it's important to note, and I think the court kind of neglected that a little bit, that the court kind of thinks, I think, that Shell produces a lot of oil and gas, and so if it reduces its production, that automatically also will lead to less emission by end users. But the problem is that Shell also trades a lot of non-self-produced products. So even if, well, the production would be limited, that does not necessarily have a huge impact on the end users and the emissions by end users. Other interesting thing to observe is that the court order is not very clear in terms of whether it's an obligation of best effort or obligation of means or an obligation of result. So in the reasoning, the court says it's best effort obligation, but in the order itself, it's not so clear whether that is the case. Another thing is that the European trade emission emission trade system, where there already is a kind of way to reduce greenhouse gas emissions by raising prices of emissions. Well, the question is all the operations that are kind of included in the ETS, whether those are also covered by the order or not. And while there it's not completely clear, it seems that the court expresses the view that Shell should, well, kind of course, meet the ETS requirements, but if that would not lead to the 45% reduction, then it has to do more, even then also for the operations that are included in ETS. Next slide, please. And so I think this is of course, very briefly touch upon some of the issues and much more to say about it, I think, and I'm also obviously happy to discuss further if any of you would like that. But I think what it shows is that the UNGP's human rights due diligence has become a kind of, well, compelling legal issue, also in terms of liability for companies, and now the cases were directed towards carbon majors. But I think this decision, if kind of also upheld in appeal, has a really well, significant impact, I think, also beyond climate change even, but also in climate change. And one may say, well, okay, the carbon majors have a lot of influence and a lot of, well, kind of in terms of scope 3, a lot of or kind of relatively large impact on cleaner greenhouse gas emissions. But for example, the same thing may go for banks or for pension funds, or because their indirect kind of connections may also be quite big. So yeah, but we have to see what happens. But I think now it's really on the legal agenda, also in terms of liability issues, and also because, of course, also the kind of envisaged legislation, which also makes human rights due diligence obligatory. So I think this really now becomes a legal field, and not only in climate change, as said, because the UNGPs, of course, also connect to all kind of other human rights related issues, such as worker issues, exploitation, land rights, or whatever. So a lot of other issues are kind of indirectly also addressed by this decision, in terms of including or filling in a tort norm or unlawful act norm in the Netherlands with the UNGP. And now the question, of course, is for many companies who also operate in other countries or are based in other countries, well, would this kind of decision also be viable in other countries? And of course, we have to observe that the Dutch law has a very broad norm for unlawful conduct. So no kind of separate torts as in some other legal systems, but a kind of, well, very broad norm. Well, and that kind of enables filling in with the UNGPs. For French law, for example, that kind of same approach may be conceivable. And well, we have a pending case there against Total, and there, of course, there's also French law which already kind of makes human rights due diligence kind of by and large binding. So that is an interesting one. But for example, for the US, UK, question is whether duty of care would exist, and also towards whom in terms of these reductions. I think, well, the question may be whether there's sufficient clarity over best effort obligations under the UNGPs, because there I think it's important to note that making the UNGPs binding has a kind of effect, because the UNGPs originally are kind of intended not as a legal norm, but also a kind of aspirational kind of thing, where well, in an ideal world, companies will do things, and maybe not so much meant as a legal norm. So making it themselves as a legal norm, that may also result in watering down kind of well, the kind of expectations from the UNGP. So we have to be a little bit careful. And of course, another question would be in other countries whether class actions as these would be possible. I have been talking too long already. My apologies for that. But I will now open the floor for any questions, and I think some were in the chat already. But also raise hand if you would like to ask something. Let's see. Well, one of the questions is how other multinational companies are reacting to this ruling. I think that's a very interesting question. I think in many boardrooms this this ruling has got a lot of attention, not only because of climate change related issues, but also in connection with human rights. Kind of well-known Ahold, former Ahold board member, but he also said that he is of course in close contact with all kind of people within the boardrooms, and he also explained that is a real thing now in courtrooms. But I think whether it's also now putting some pressure on that's the second part of the question on states to do something, well, that I think is less obvious. But I think many companies are kind of afraid that this kind of decisions will have an impact in other countries too. For example, what we have seen with the agenda case, where of course states were involved, but then the decision by the Supreme Court really kind of I think triggered some other courts to kind of implement comparable approaches, where we have seen that happening, for example, in Germany, in France, Belgium. So this may really have an impact on what happens in other states too, but then especially I think in courts. Another question which is very relevant, I think, is it says, well, with the non-environmental types of impact, it's less easy to measure and compare. And so what does that have? What does that mean in terms of what the court did in the Shell case? And I do agree with that. Of course, greenhouse gas emissions are much more easily assessed in a kind of more scientific way, by saying, okay, well, we can reduce X percentage and we can really measure it. Whether, for example, impact on workers' rights is less easy to measure, because that's to a certain extent also a perspective of people on what happens and how they feel they are impacted by business operations. So indeed, that is a little bit less easy to measure, though I think it's still important to come up with kind of methodologies to kind of, and the European Commission also announced to come up with a social kind of taxonomy, as they did with the green taxonomy in terms of climate change, biodiversity, and environmental impact. So apparently, I think there is a huge need for kind of more objective, or maybe not objective, but kind of more agreed upon methodologies to measure human rights impact. But I think that doesn't mean that this has not become a legal issue and liability issue in terms of other types of impact, because what kind of follows from this decision is that you have to kind of implement human rights due diligence, and if you don't do that, and then there may be an issue in terms of also liability. So I think it is a very important thing also for lawyers within companies because of course many companies do a lot of things in terms of human rights due diligence, but what I kind of usually see, not with all companies of course, but usually see, is that it's mainly kind of embedded in other departments than the legal department, and sometimes the lawyers are not so much up to speed in terms of what UNGPs mean and what they kind of imply in terms of also legal issues, and so there I think it's also important now for the lawyers to come up to speed in this area, and not only in climate change related things, but also beyond that. Let's see whether there are any other questions. Martijn, if I may, you go here.
Perhaps I should clarify my question, the
Yeah.
very first one.
Yeah.
I was thinking if companies want to be sure they are not, let's say, approached by NGOs or the government to the court, they perhaps could, and they would implement the science-based targets that have been developed for companies. Perhaps then they could have certainty that they do enough, that they are ambitious enough, and that they don't have to fear they are dragged to the court. Of course, 100% certainty is not real, but I wanted to give as Global Compact a positive picture for companies.
Yeah, well, thank you, Hugo. I think that's an excellent question. And I think indeed, here companies, the best thing to do probably is to take a kind of proactive approach, where you try to develop indeed kind of best practices to really kind of advance things and move things in this area. And that's climate change related, but maybe also for the more kind of, or the other types of impact. And this kind of where you really show, well, we're trying to implement best practices. So we are actually already kind of implementing a kind of best effort approach to do our things. And I think that may really help, because then the court may say, okay, yeah, there is apparently is a kind of best effort obligation. And yeah, the companies are doing things also collectively, for example, with UN Global Compact, to advance things and to implement more stringent measures to indeed reduce greenhouse gas emissions or to prevent other types of impact. And I think then that may also make a court think, okay, well, apparently they did their thing in terms of really trying to do the implement a best effort approach to change things. So then I think they met the kind of legal threshold that was set in the Shell case. And there the interesting thing is, of course, the best effort obligation imposed in the Shell ruling is very, very broad. And now many lawyers are saying, okay, but we really do not know what we have to do, because the court is not clear about what should be done. And then sometimes I also tell them, well, that may also be an advantage, because you may choose what to do. And maybe you can better now proactively choose and do the things which are kind of, well, practical and can be realized. And then waiting for courts to come up with things which may not be practicable and cannot be realized in practice. So there, I think it is really important to take this proactive approach, and also for not only climate change, but also other domains of impact, and try to show, well, we are indeed implementing this best effort. And then I think in the next case, a court may think, okay, well, they did what's expected, because they indeed have implemented this kind of best effort approach. So that is sufficient in terms of liability, and meets the kind of legal threshold. So a very important question, I think, and also very important thing to do in terms of trying to develop these kind of practices. And of course, that's what the UN Global Compact is continuously doing. But I think now the new element in this would be that you also have to kind of look at it from a kind of legal perspective, and also involve lawyers in terms of, well, indeed, if we look at this kind of best effort approaches, well, what is then sufficient in terms of legal norms? And, well, for example, interesting questions maybe UNGPs, for example, require stakeholder engagement. And now, well, interesting, but then of course the question is, well, what is a stakeholder and who qualifies as a stakeholder? Well, we have some kind of broad ideas about that, but obviously in many cases, if you try to do best things in terms of stakeholder engagement, well, you will always find people who say, oh, well, I was a stakeholder and I was not involved. And then the question is, well, how far does that kind of involvement reach? And there, I think we also have to come up with a kind of, well, legal insight in terms of where we feel it is sufficient. And so we can learn from, for example, administrative law, which has some ideas about that, and the other kind of legal concepts. So from that perspective, we have to indeed also develop that from a legal perspective. And I think if that's being done, well, then I think courts are kind of willing to accept that that's probably what the standard is, in terms of what companies can do, and maybe also willing to say then, well, that kind of meets the legal threshold and thus also prevents liability. Of course, 100% certainty we won't have, but I think the kind of, as you suggest, I think it's a very good suggestion to do proactive approach, but now also including the legal perspective would be excellent idea also for of course your organization. Yeah. Let's see whether we have another question. Well, let's see. The question is what I would advise towards executive board members, supervisory board members, and risk and legal managers. What's the sense of urgency, and how should they manage this complexity and communicate about it? Also with, of course, the COP conference in Glasgow coming up. The sense of urgency, I think, I hope that has reached the boardrooms, but of course the sense of urgency is not only the Shell case, I think, but climate change as a whole. But of course, this Shell case, I think, also shows that there's a new element to it in terms of legal liability. So it really is a thing which should be on the board agenda, I think. And what would be the advice? Well, I think the advice would be, as kind of also suggested by Hugo, to try to come up with proactive approaches, not wait till next courts. Also develop new rulings on this and kind of force companies to implement measures which are kind of maybe not practical or not realizable in practice, but try to take this proactive approach. And also from a legal perspective, try to come up with approaches which are kind of meeting the requirements the court now may have set. And so far, the court ruling is very broad. So at this point, anything goes. Of course, until a certain threshold, but I think, well, by and large, the companies are now still free to kind of develop their own kind of best efforts approaches. So that I think now is the moment to do things and try to develop that, and I think also within the UN Global Compact. So and how then to manage this complexity. Of course, that is challenging, and of course, easy solutions are not able here. For example, in climate change, I think it's very important to collaborate with others, because Shell by itself probably is not able to reduce greenhouse gas emissions by the kind of end user, because, well, many other companies are also selling fuel. So if the fuel becomes more expensive, for example, and price raise, well, then probably there will go to the competitors. So that may not be the solution. And so probably you need to bring about changes in markets. And there, I think Shell has to kind of collaborate with other oil carbon majors, but maybe also, or especially also with financial institutions, for example, with investors, to really try to bring about these changes. And I think if for example, investors are kind of divesting from carbon majors, for example, who are not kind of doing anything or not doing sufficient things in kind of the kind of needed changes or required changes, well, that kind of may also put pressure on markets, and they are kind of now starting to do that. So that may put pressure on markets, which may also help others to change. So this kind of collaboration, multi-stakeholder collaboration, I think is very important to bring about these kind of changes. So that is a thing, and a manner to manage this complexity. And then communicating about it, well, that's also a very interesting and relevant question, because, well, what may be the effect of communicating, which kind of Shell did, they had kind of their company reports saying, well, we have a policy where we try to reduce 45% by 2035, and we have kind of met and kind of measured all kind of emissions, and so these are kind of emissions this is going to do. Then, as in this case, NGOs may also say, okay, well, that's interesting. So Shell, is already doing things, but we have a lot of information on what they do, but it's not, we feel it's not enough. So being transparent about what you do may also kind of assist in kind of bringing cases against companies. But that's a kind of, well, a little bit older discussion because that's not only with greenhouse gas emission, but kind of connected with reporting on sustainable development as a whole. And of course, there, well, now some discussions are going on, well, whether reporting kind of should also require a safe harbor in terms of, well, these reports cannot be used for liability purposes, for example. So yeah, I'm not so sure whether that will really stick. And it's a kind of legal kind of reasoning and concept which is used in the US, for example, in connection with the California Transparency Act on child labor. But yeah, I think in Europe, I'm not so sure whether this will kind of be accepted. So what I feel is that better, I think, to kind of develop these kind of approaches and be transparent about them, which are kind of considered to meet that legal threshold. And then, yeah, there's no problem about reporting about it because you really show what you are doing and trying to do and try to meet the legal threshold. So that then only would support, I think, cases in court in terms of, well, we are doing the right thing, so to say, and maybe also prevent court cases, I think. So, yeah, it is complex, but I would not recommend to now stop reporting. Now, that's not possible either because, well, there are some legal requirements to report, but the kind of idea, well, we should be restrictive in terms of reporting about things, I think that's not the right way to go. Probably much better to really show the things, the best practices we are developing to make things better, so to say, instead of kind of reactive and restrictive approach.
Martijn, Jan here. I was asking these questions also about reporting, and you are reacting on that. And you already said something about US legislation. And I remember, for example, a few years ago, maybe a decade ago, Nike withdrew their report, sustainability report, because there were allegations that they had something in the report what wasn't true. So they were having a big risk by communicating things that, yeah, they didn't had the proof yet. So I think with this whole climate thing and the consequences in the deeper, let's say, supply chains, it's very difficult. And of course, yeah, there are many, I think, legal risks. So it could be that if you look at your sustainability reports, that more legal persons are looking, what are we really communicating? That is already happening, but I think it will increase. So how transparent will those reports be at the end? And we are seeking for transparency, but yeah, from a legal perspective, that limits the transparency, I think.
Yeah, no, I think you're right. And of course, this is a kind of intricate balance in terms of, well, we want to be transparent on one hand, on the other hand, while being transparent also kind of implies or implicates some legal risk. And you kind of describe, well, those, I think, and so, yeah, the question is how to deal with that kind of balance. But as said, I think, of course, there is a risk in terms of liability, people saying, well, there are things wrong in the reports. And obviously, of course, well, you have to try to be kind of, well, to have put in correct things. But still, I think, of course, non-reporting can also have other consequences, for example, in terms of reputation, and also in NGOs who are trying to sue companies which are not transparent on what they are doing. So, of course, there is a risk in reporting, but also risk in non-reporting, legal risk, but also reputational. And I think reporting, as said, can also have a kind of advantage in terms of showing that you meet the kind of legal thresholds. So, but that's kind of new because, well, what happened now with this court shell ruling, now this kind of issue becomes also legal issue even without legislation in the Netherlands yet. So that also, I think, then triggers a kind of new element in terms of reporting, because I think it's also important to prevent this kind of procedures, to show that you're trying to implement that best effort approach. So yeah, I do agree that easy solutions are not found here, and we cannot say, well, you have to report in this manner all the time, or you can do things from another perspective. But the problem is that, yeah, we cannot really say, well, in this case, you can always report this, and in this case, you should not report it. That also, well, depends on many circumstances. So that is a kind of, well, very important and also interesting, I think, and difficult legal question. And I think, but they're kind of easy answers in terms of, well, how that should be solved. That really depends on the type of issue and the way it is reported. But in general, I would say this, I think, in my view, would not be a reason to stop reporting or try to really kind of restrict reporting on these issues. On the contrary, I think being transparent on well, kind of implementing best practices, I think is only helpful in terms of trying to prevent legislation or procedures like this. I think we have to wrap up, I'm afraid, and of course, much more to be said, and I'm happy to explore further with those of you who may be interested in terms of new questions or issues that may arise. But I think thank you very much for your attention for now, and back to you, Linda.
Yes, well, thank you, Martijn, for your rich and sharp analysis of this court ruling. It was also good to learn more about how you connected it with other relevant topics that we are working on and other relevant projects like the Climate Ambition Accelerator. We are doing together with the UK as a Global Compact Network Netherlands, and stakeholder inclusion, reporting, and our activities on human rights and due diligence. So thanks a lot for that, and also thank you everyone for participating in this webinar. Hope to see you also at upcoming events of Global Compact Network Netherlands. Thanks a lot.
Thank you very much. It was a pleasure to be here.